Hello everyone, welcome to Kamadhenu Law Academy. Today we are going to discuss about Constitution 2, Constitutional Law 2. What are the learning outcomes in this video? You are going to learn about the concept of federalism in Indian Constitution, discuss the constitutional scheme of distribution of power between center and state, cooperative federalism, constitutional provisions on freedom, trade, commerce and intercourse, local self-government, constitutional status of Jammu and Kashmir and official language. See here what is federalism means. It is division of power between center and state. Constitutional scheme is that the financial, administrative and legislative scheme, how it is divided between center and state. Okay, cooperative federalism is how center and state together for the development of country work together is cooperative federalism. Constitutional provisions of freedom, trade and commerce and intercourse that you are going to study. Local self-government is your Panchayat Raj, 73rd Amendment, and Constitution of Kashmir is abrogation of Article 370. Dear children, please see only Article 370, special status to Jammu and Kashmir is abrogated, not Article 370. Article 370 is there in the Constitution, and you are going to study about official language, which language is used in regional and whatever it is in center and regional. Okay. So, concept of federalism in Indian Constitution. In synopsis, you have introduction, features of federalism, what is quasi-federalism, case laws and conclusion. So, federal system. The Constitution of India has not described India as a federation. However, Article 1 of the Indian Constitution describes India as union of states. That is, all states together. This means India is a union of comprising various states which are an integral part of it. Here, the states cannot break away from the union. They do not have power to cede from the union. If in a true federation, the constituent units or the states have the freedom to come out of the union. India is not a true federal government because it combines features of federal government and the features of unitary government, which can also be called as quasi-federal government. What are the federal features of Indian Constitution? Two sets of government, that is the central government and the state government. They are working separately. Both their governments are different. Division of power, that is the central government and state government powers are divided under Indian Constitution only. The 7th schedule of the Indian Constitution provides how division of power is made between center and state. Both center and state government have separate power and responsibilities. The 7th schedule of the Indian Constitution consists of union list, state list and concurrent list. It is very important. Whenever you are telling about division of power, you have to go to 7th schedule. It is one of the important thing. It says in union list how many entries are there, in state list how many entries are there, in concurrent how many, and how their work is divided, who can make laws on which subject matter. That is how it is. So how it is divided, that we are going to discuss. I'll tell you in the later videos. You please continue to listen. Then we have written constitution. We have 395 articles and 22 parts and 12 schedules. Then supremacy of constitution. Constitution of India is regarded as supreme law of land, and no law can made against the constitution. Okay, no law can be made which is contrary to constitution or which is against the constitution of India. Supreme Judiciary. The Supreme Court of India is regarded as the Supreme Court of the country. The decision of the Supreme Court is binding upon all the court, and it has power to interpret the articles of the Constitution. So, Supreme Court can interpret articles in the Constitution. Okay. Then bicameral legislation. In India, the legislature is bicameral. It has two houses, and that are Lok Sabha and Rajya Sabha. The upper house of the parliament which represents the states in Rajya Sabha, and the lower house of the parliament which represents the people in generally in Lok Sabha. Then quasi-federal system. What is this? We'll see. There are many examples which clearly shows that Indian constitution has federal features, but it also shows that it is evident that it has quasi-federal features too. Some of the examples which show that India is quasi-federal are division of power between central and state, but central government has given more power than the state government. Okay, Parliament can override the laws which are passed by the states for the reason of national interest. If any state is making any law which is only helping that state, then Parliament can override and override the power of states in the national interest. Then residuary powers are vested in the central government. What is this residuary power? See, Article 248 says about residuary power. When our constitution was made, there was colonial violence within us. The states were fighting themselves. We were not fighting with other countries, but we were fighting in ourselves. So we wanted a strong center. Everyone recommended, many of them in the committee of framing constitution recommended that center should be strong. So whatever the lists, subject matter which are in the list 1, list 2, list 3, if any chances where the subject matter is not there in those 3 lists, then the power is vested with the central government to make laws, rules, etc. Major taxing powers are also vested in central government. Parliament does not represent the states equally. However, in a pure federal government, the upper house of the legislature has equal representation for constituting the states. But in our Rajya Sabha, the states do not have equal representation. The populous states has more representative in Rajya Sabha that of the less populous states. In India, citizens are allotted citizenship, which is not a feature of pure federal government. As a true federation nation, citizens are allotted dual citizenship. First, they are the citizens of their provinces, and then they are the citizens of the nation. For example, you have USA. Then Dr. Ambedkar listed several features of draft constitution which mitigated the rigidity of legalism of federalism in the historic speech in the Constituent Assembly in November 1949. The following features are as follows. Article 246 of Indian Constitution distributes legislature power between union and state. It gives union exclusive power to legislate in respect of matters contained in list 1, concurrent power legislate in respect of matters contained in list 3 of the 7th schedule of the Indian Constitution. See, 246 is very important when you are talking about the power of Parliament to make laws, power of legislative power of the government. Okay, Parliament is given power to legislate on exclusively state subject matters, namely 249, 250, 252, 352 and 353. There are other provisions also which are operative unless Parliament made any contrary provisions or the word to the same act. Article 368 of the regarding amendment. Okay, in state of Rajasthan versus Union of India in 1977, former Chief Justice Beg called the Constitution of India as amphibian. He further stated that if our constitution creates a central government which is amphibian in the sense that it can neither be federal or unitary according to the need of the situation and the circumstances of the case. And also in S.R. Bommai versus Union of India, in this case, the court stated that the president should exercise his powers only after his proclamation is approved by both the houses of the parliament. The power of president to dismiss a state government is not absolute. In state of Haryana versus state of Punjab, the term semi-federal was used for India, and in Shamsher Singh versus state of Punjab, the constitution was called more unitary than federal. So you can refer n number of cases for that. This is the conclusion that the Indian government is quasi-federal in nature as it contains features of single citizenship, single constitution, flexibility of constitution, which are not the features of pure federal government, which is only followed in the United States of America. Although the Indian government contains features of federal government such as division of power, partly rigidity of constitution, it does not considered as pure federal government but as a quasi-federal government. So now we are going to discuss about distribution of discuss the constitutional scheme of distribution of power between center and state. It is interconnected. Please see legislature power under Article 245 clause 1. Okay, it states, it gives provisions to the to make laws on the lists given. Okay, legislative power in plenary means it is fully constituted. The power of the legislature under Article 245 to enact laws is plenary power, subject to only just legislative competent and not other constitutional limitations. The power to make laws includes to give effect prospectively as well as retrospectively, in future or in before. The legislature has power to alter existing laws, the power to validate law retrospectively, subject to the other constitutional limitation, and auxiliary power to the legislative on the particular subject. Okay, distribution of legislative powers on subject matter. What all subject matter, list 1, list 2, list 3 is given. Depending on that subject matter, the power is given. In America, Australia and all, they didn't want to give state more, they wanted to give state more importance than central. But Canada saw the whatever the unfortunate things happening in USA, so they thought to make center strong. However, we adopted it from Canadian constitution, so we are also following making center strong. Okay, so these are the subject list and state list, union list and concurrent list subject matters, which are divided according to that. You will get it in our notes. You kindly contact Kamadhenu Law Academy for your further notes. So the concurrent list consists of 47 subjects. New entries are 11A, 17A, 17B, 20A and 33A has been added. Okay, this in the words of Pele, a twilight zone as it were for both the union and the states are completely legislate in this field without coming into conflict. So in concurrent list, both union and state can make laws. That is why it is put into concurrent list. Then residuary power, I already explained residuary power, that is when the entries are not there, then center has got the power to make laws. To make the center strong, we opted residuary power and to center. Okay, parliament power to legislate on state subject. See, in list 1 is for union list 2 is for state and list 3 is for both center and state. But parliament when making laws can certain times in certain situations it can make laws on state lists also. There are exceptional cases where parliament has made laws on state subject. You can take Article 249, Article 250. Okay, many like that, many examples you will get. When failure of constitutional machinery, when there is any treaties with international agreements, that time state power will be little down and parliament power will be uplifted. What are administrative relations? Chapter 2 of Part 9 of the Constitution contains a provision related to administrative relations between union and state. The executive power of the union extends only to those matters which are mentioned in union list. and over which the parliament has legislative power. The states are moreover expected to comply with the laws made by the parliament and are not to impede the exercise of the executive power of the union. The union can exercise administrative control over the state through following methods. How union can control state is through this following methods. Okay, in Article 256, the Constitution signifies the respective obligations of the union and state government. It provides that the executive power of the state has to be exercised to ensure compliance with the laws made by the parliament, and the union government is empowered to give necessary direction to the states. Okay, then in 257 clause 1 further provides that the executive power of every state shall be so exercised as not to impede or prejudice the exercise of the executive power of the union, and the executive power of the union shall be extended to giving of such direction to a state as may appear to the government of India to be necessary for that purpose. Thus, within the sphere covered by the state list, the union government can give directions to the state government. Then Article 257 provides union government can issue directions to states regarding the construction and maintenance of means and communication of national and military importance. Then also it can give the reimbursements of expenses incurred by the states in railways. In case the state government fails to comply with the directions of the union government, the president has been empowered by Article 365 of the Constitution to hold that a situation has arisen in which the government of the cannot be carried on in accordance with the provisions of the Constitution. President's rules may be imposed on the state. Delegation of union functions to state. 258. President may, with the consent of state government, entrust that the government or its officers functions in relation to any matter to which the executive power of the union extends. Extra costs union government. Okay, appointment of government. It is the power of president to appoint the governor. Public acts, records, and judicial proceedings also. Article 261. Okay. Judicial proceedings. What Sherwai has told, according to him, the object of the full faith credit clause is to prevent the states of federation from treating each other as foreign states by virtue of their independence in their own respective spheres. In United States and in Australia, the federal government is a government of enumerated powers, the states having independent constitution of their own. In India, the position is different. The states of British India never independent constitution of their own, and our constitution is a constitution both for the union and the states. So interstate water disputes, interstate council, all India services, these all are administrative relations between center and state. Okay, how they are, their relation for administration is carried on. 262 clause 1 empowers parliament to make laws in the adjudication of the disputes relating to interstate rivers. Okay, then interstate council, president can establish interstate government council to investigate and discuss subjects of common interest, which is good for all public interest. And Article 312 provides parliament can create all India service following the by 2/3 majority blowing the resolution by Council of States passed by the authority of the central government dominant over the states. Interstate commerce commissions, okay, 307. Emergency provisions 352, 356, 360. During emergency, president gives directions to state governments regarding the manner in which states have to exercise their executive power. Okay, Dr. Ambedkar referred to provisions as safety values and expressed the hope that there would to them. Unfortunately, it has often been misused by political parties to state governments which are not promoting the interest of ruling party at the center. Financial relationship, again it is the between the center and state. The tax revenue, taxes levied by central but collected and appropriated by the state. For example, stamp duties, excise duties, tax on sale and purchase of goods of interstate trade and commerce. These are all the tax revenue between union and state. 268, 269, 270. This category also includes the duties and taxes mentioned above in the first and second categories, and all cess, surges, taxes. Taxes for the purpose of center. This category includes tax related to customs, corporation tax, taxes on capital value of assets of individual and companies. Okay. Taxes for the purpose of state. This category includes tax related to land revenue, stamp duty, except in documents included in union list, succession duty, estate duty, etc. Okay. Grant in aid. It's the help, grant in aid. The above mentioned sources are not adequate for the states to carry out development programs, and the Constitution provides grant in aid shall be made in each year by the Union to such states as Parliament may determine to be in need of assistance. Whenever they need some assistance, particularly for the welfare of tribal areas, including the grants to Assam. Okay, this is financial relationship. Now we are getting into the cooperative federalism. What is the meaning of cooperative federalism? KC Ware definition of quasi-federalism, examples of cooperative federalism, and conclusion. So what is the meaning of cooperative federalism? Federalism is the both branch of which envisages that all levels of governance, which are center, state and local bodies, should cooperate with one another in order to achieve the collective goals for the benefit of the society. All these bodies